All right, welcome everyone to our first legal pop-up of 2025. I want to welcome you to Legacy Legal and Consulting Firm. We are a virtual law firm for purpose-driven CEOs on the go, especially if you are serious about building a profitable, sustainable, and scalable business. We help you do that as you protect your brand, build a legacy, and secure your wealth. And so I want to welcome you to our first legal pop-up, and we're going to do this in two parts. So I am going to record the first half, which is the content, and then I'm going to stop the recording because the content piece is going to go up online so people can have access to that whether they register or not. But the Q&A portion, what I like to do in our legal pop-ups is I like to honor everyone who registered. You took the time to sign up, register, and to be here. And so the Q&A portion we're going to save towards the end. So if you have questions, make sure you save that to the end. I'm not able to see the chat when I am doing a legal pop-up. I'm going to come on screen in just a moment for those of you wondering. And what's going to happen is I'm going to record the Q&A session separately, and you're going to get access to that as well, okay? So again, welcome. All right, so now you should be able to see me. So let me introduce myself. I am Shayla Jackson. I am a trademark and business attorney. I'm also the CEO and founder of my law firm, Legacy Legal and Consulting Firm. Hey, Crystal. Hello. Welcome, Jeffrey. Welcome. I believe it's Kirsten. I hope I said that correctly. One of the things that I want to say coming right out front is this is not a webinar. This is not a webinar. This is not a webinar. If I had to do a webinar, y'all will be waiting for some time because that means slides are included. But this is a legal pop-up. And so during a legal pop-up, it's a conversation where I'm going to be giving you some things to consider. There were some questions that came through in the Q&A. So during the registration piece, so I'm going to answer those questions. And then you have more during the Q&A session. That's where we're going to get into it. Now, I'm someone who starts on time. I understand we are CEOs on the go. So you have other things. So I want to get you in and I want to get you out. All right. Let me give you a little bit more about my background. Later on this year, December, will make 10 years I have been licensed to practice law. But I have been practicing law probably since my first summer of my first year of law school because I started out in education law, representing students in expulsion hearings before the school boards out in Oakland, California. Also did some education law after I graduated law school, representing juveniles as they transition from being incarcerated to going back into school. Many folks don't understand how complicated that process is and how many of our youth, especially in the state of Maryland, fall through the cracks. And unfortunately, that becomes a violation of their probation and they get sent back. So I started out there. I also started out in criminal defense law. And so my representation style, my style of lawyering is holistic, which means that some of you and some of my clients come in thinking that they have this legal issue, but because I have trained and studied in holistic representation, I'm looking out for my clients 360, which means I'm looking at the whole picture, not just the one single issue. All right. I moved from educational law, criminal defense. That's where I primarily trained as a trial attorney, doing litigation work, doing some representation before many agencies. Welcome everyone coming in. I'm just giving a little bit of background as everyone is getting settled in. I want to welcome you to Legacy Legal and Consulting Firm Pop-Up. Again, my name is Shayla Jackson. I'm a trademark and business attorney. I'm just introducing myself a little bit and my background so that you understand where I came from. So I started out in education law, criminal defense for juveniles, but also for adults as well. And then I transitioned to business law. Now, business law wasn't just something that came out the blue. When I was in college, believe it or not, I partied. And because of my partying, I was a club promoter. So I got picked up to be director of public relations for a company at LLC as we threw parties for college students. That happened my freshman, sophomore year of college. And so I got really interested in contracts. I got really interested in how does business operate? How does this thing work? And then I started my own photography business before I went to law school. Once I went to law school, I could not do law and also keep my business. So I shut down the photography business and I graduated from Georgetown Law. And after that, I transitioned into business law, in which I started teaching first the laws of doing business. So I started out teaching. I actually have, hey, go Hoyas. I actually have a teaching background. So I taught law at Wilson High School, as well as Columbia Multicultural High School in DC. I also spent 1 year in the Clinical Teaching Fellows Program at Georgetown Law. That's their LLM program after you graduate, teaching law students how to teach law, not in the legalese. I'm sure some of you have encountered lawyers where they talk in legal language and you did not go to law school. That does not mean if you don't understand them, something's wrong with you. The thing is when we come to teaching, and what you're going to learn is we're talking today during our legal pop-up, is that there is a way that there's a way to communicate the law that is not riddled in legalese so that you can understand. So when you are looking for attorneys, I'm just going to add this and we're going to move into our content. Your attorney should never make you feel stupid because you don't understand something. So if you don't understand something that I've said here, or there's a question, but you're not sure what the question is, ask the question. Even if you're not sure what the question is, just say, I have a question, but I'm not sure how to formulate it. And that's my responsibility to help you come up with the question. So I never want you to feel like, I don't know what to ask. Just you have a question, even if you're not sure what it is, and we'll figure it out. All right. So that's a little bit about me. I graduated again from Georgetown Law School, started my own law practice, which is Legacy Legal and Consulting Firm. And I want to welcome you here for our first legal pop-up of 2025. This is a legal pop-up. This is not a webinar. Okay, so there's no formal structure in terms of agenda or what we're going to cover. Whatever questions you have, that's where we're going to go. All right. Now, we are talking about intellectual property basics. So this is the basics of licensing, intellectual property licensing. So I'm going to kick off by giving you my definition of intellectual property. And then I'm going to delve into some things that you need to consider when licensing your intellectual property. Once I finish the content portion, I'm going to stop the recording. And then I'm going to start a new recording for the Q&A session. The Q&A session you will have access to because you took the time to register. So don't worry about it. During the Q&A session, that's where you'll be able to ask your questions, and I'll answer the questions if you submitted them during your registration. All right, so intellectual property, my definition. This is my definition of intellectual property. Intellectual property is the real estate of the mind. It is the real estate of the mind. So I want you to think about real estate. Everything that you can do with real estate, you can own it, you can own it, live in it, you can license it out, meaning you can rent it, or you can sell it. It's the same thing you can do with intellectual property. So when we're talking about intellectual property licensing, we're talking about renting out our intellectual property, meaning we're not giving away ownership. We keep ownership, but we're allowing someone to use it. So I don't know if any of you are into real estate investing or you are a landlord, but I want you to keep that in mind. Even if you have rented before, I want you to keep that in mind when you think about intellectual property, because the same parameters that a landlord would have regarding the use of their property, right? What you can do, what you can't do, is the same thing you would have as a landlord for your intellectual property. What can they do? What can't they do? All right, so there are different types of intellectual property. You have trademarks, which deal with marks that act as a source identifier on a product or service, identifying it as belonging to a particular business. What the heck does that mean? It means this. When you see this mark, you automatically know the source. So when you're on a road trip and you see the golden M in the distance, because you recognize that golden M as belonging to McDonald's, that is a trademark. I see it, I know the source of it. It gives the consumer a sense of security in the marketplace, that they know the quality of the product or service that they're going to get because they are familiar with this brand. Same thing. When you see the swoosh, I know that's Nike. And so when we talk about trademarks, we're talking about not just branding, because not every brand is a trademark. We're talking about marks that are strong enough, distinct enough to identify a product or a service as belonging to a particular business. This is important when we talk about licensing, because there are particular things you need if you're going to license your trademarks versus if you're going to license our next category of intellectual property, which is copyrights. Okay, not copyright like in COPYWRIT, which is, you know, the writing that you do in your marketing and on your website, but copyright as in COPYRIGHT. Now, many people think that copyrights are just one right, but it's not. It's a bundle of rights. Copyrights are a bundle of rights. So copyrights are not something, you don't get copyrights when you register. Copyrights automatically apply the moment an original creative work of authorship is fixed in a tangible format. What the heck does that mean? It means right now we are recording this video. This video does not have copyright protection because it is not fixed in a format just yet. The moment that this recording ends, it is going to go into an MP4 format. It's going to have different formats, which means the moment it's fixed, meaning you can't really change it easily. It's in a fixed format. Copyright protection automatically applies. I did not have to register in order to have copyright protection. Immediately it applies. So copyrights are for creative works, original works of authorship. Thank you, Crystal. Original works of authorship. Now, what does that mean? I want you to think about what creative works are. Some of you speak your speeches, this video, so videos, music. If you are an author, your books. What else? Social media content. I have a newsletter I need to get ready to write. My emails that I write is under copyright, as long as it's original. And here's the thing, under copyright law, original doesn't mean original from scratch. If there is some element of originality in it, it has copyright protection. So if you notice the difference, trademarks have to be distinct and they have to be strong in order for trademark protection to apply. Registration is not required for trademark protection. It applies automatically, but it only applies if it's in use. Copyrights are for original works of authorship. So your logo is something that can fall under trademark and fall under copyright if it's used correctly. Now, the reason why I want to make the distinction between those two is so that you understand the difference between what falls under trademark law and what falls under copyright law, because sometimes they overlap, but they're not the same. Trademarks are based on use. Copyrights are based on originality and being in a fixed format. Here's the key about intellectual property. Just like with real estate, if you have a concept and a design in your mind, no protection applies. No protection applies. Protection applies when it's in reality. So as long as it's in your head, there is no protection. Thank you, Jeffrey. There is no protection. This is why, and we're going to talk about, when we talk about intellectual property licensing, I want you to know that I'm going to focus on copyrights and trademarks because those are the two primary areas that majority of business owners have to license. Patents are another type of intellectual property. Okay, that deals more with inventions, ideas. But here's the thing, patents are more for, when you apply for a patent, it's more for the public or other institutions to be able to take advantage of. That's why they incentivize you to register a patent, but it's also to protect the invention. And then you have another area of intellectual property, which is trade secrets. I'm not going to delve into patents and trade secrets the most, but trade secrets, I want you to know this. The key is it's a secret, which means that it is information that is connected to your business making money. So it's proprietary information that's kept confidential. Think about it as the Coca-Cola recipe. Your secret sauce ingredient, you keep that close to the vest because it's your money-making sauce to make sure that what you're putting out into marketplace, nobody can take advantage of. So with your trade secrets, this is not something you license unless you're going to do a franchise or you're training other people to do what you do. And this is where trade secrets are not necessarily protected. There's a body of law to defend against trade secrets being stolen, but this is trade secrets is where you really protect it under contract law. Okay, it's really under contract law where you want to protect it, because the key thing about trade secrets is it has to be kept secret. So the moment it's not being kept secret, in order for you not to lose the secret part of that trade secret, you have to make sure it's protected under contract law. Okay, so a contract. So those are the four main types of intellectual property. I usually teach on another one, but for the basics of our legal pop-up, today, that one is not important for what we're talking about. So when we talk about licensing our intellectual property, remember, think about leasing a house. I want you to think about your intellectual property as your home that you own it belongs to you. And let's say that it's a home that it comes furnished. So every part of the furnishing in your home has a piece of your intellectual property that you are considering renting out to someone else. Okay. Now, you have trademarks, copyrights, patents, and trade secrets. I'm going to focus on the first two, trademarks and copyrights. Now, before I delve into my list here is what I want to tell you. When we talk about licensing intellectual property, it's not enough for you to have the content. If you want maximum protection, because we're going to talk about protecting your brand here, before you get ready to license it out, let me tell you, if you are sharing content with clients, you're already licensing your intellectual property. Okay, you're already doing the basis of intellectual property. If you are giving out content, you have ebooks, downloadables, that's already a license as a part of the sale or as a part of the download. Many of you probably maybe you don't have this, but if you ever, some of you, no, okay, so all of you know me in my law firm capacity. I have a separate business where I do contract templates. Every single one of my templates come with a legal notice. Now, in that legal notice, what is included is a copyright notice, but it also has copyright licensing terms, because licensing is not just the huge renting out your intellectual property. It's even when people buy products from you, even digital products, and you giving them, remember I said, licensing is all about what you can and can't do. It's leasing. So here's what you can do and here's what you can't do. But your first step is identifying what type of intellectual property is it? Is it trademark or is it copyright? Or if it's patent or trade secrets, you need to identify what it is. Once you identify the type of intellectual property, now you want to identify what can they do and what can't they do. So for example, I'm using this as an example. My contract templates it falls under copyright law. Why? Because it is a creative work. It's an original creative work. It doesn't have anything to do with my branding part, trademarks. It's not acting as a source identifier. So it falls under copyright law. Now, my logo that's on the contract template, it can fall under both copyright and trademark law. Are y'all following me? If you follow me, just put yes in the chat. You following me? I want to make sure you're keeping up with what I'm saying. The overlap. Now, when I have the template, what happens is that I put a licensing terms in the template. It's not long, y'all. It's a paragraph to say this is what you can't do. Remember when I said that copyrights have a bundle of rights? So when you're thinking about licensing out your copyrights, we're talking about which right are you giving them? So for example, under copyright law, there is a right that they can print. There's a right that they can distribute, meaning they can give out copies. There's a bundle of a right where they can, depending on the type of intellectual property, they can broadcast it. So think about radio, music, they can broadcast that. Think about, y'all, one of my favorite Christmas one of my favorite Christmas movies every year is A Christmas Story. And one year I was traveling, so I got to actually go to the Christmas Story house up in Cleveland on the 50th. I think it was the 50th anniversary. It was like my childhood coming alive. But a part of that movie, I don't know if y'all have ever seen that movie, but a part of that movie, they listened to the radio. They back in the day, they used to broadcast stories on the radio. That's broadcasting. Okay, it's a story, but it also can be broadcasted. Other parts of uh, bundle copyrights, what I said, you can print, you can make copies. So you can make copies of it. So I don't know where everyone's educational background is, but in college, I used to work at University of Maryland, College Park after I graduated. I graduated there, and then I worked in the department. And one of the things that the professors could do for educational purposes is they could make copies of certain texts, but they had to have the right to do so. So you can make copies. That means that if you are the owner of your intellectual property, nobody has the right to make copies of your work without your permission. That's a right that you have under copyright law. Another bundle of right that you have under copyright law is you have the right to make derivative copies. Now, what's a derivative copy? So, for example, once we finish this video, that's going to be the original copy that's in a video format. But say that I want to create reels from this. I want to take this video and create reels and put a couple of clips together. Now I'm creating a derivative work. It's a work that is created based on the original. I have created another copyright, but it is a derivative work of the original. Those bundle of rights fall under copyrights, which means you don't have to give away the full copyright. You could give someone the right to make copies, but not the right to broadcast. You could give someone the right to print. So, for example, there are some ebooks that I provide, and you have the right to print it for personal use, but you don't have the right to create derivative works. Now, the reason why I want to lay this out for you is important to understand is because if you're going to license your copyrights, you need to be very clear about what rights you're giving and what rights you are not giving. Okay, so we're already there. All right, so let me give you some considerations, and I want to give you something else too, because here's the thing: ownership, especially of copyrights. If you're going to transfer ownership of copyrights, which is not what we're talking about, you require a contract. If you want to own it, you have to have a contract. But if you want to lease it, if you want to rent it, if you want to license it, you don't necessarily need a contract, but a contract is key if you want to put the parameters in place about what they can and what they cannot do with your intellectual property. But most importantly, when they have to stop using it. You also want to make sure that you have quality control built in, especially if you're going to be licensing your trademarks. In order for you to keep the protection of your trademark, you need quality control built in, because remember, trademarks are about source identifier. You can lose your trademark rights if you don't have quality control built into your contract. So here are some considerations if you are going to be licensing your contract. So I already talked about one. You want to identify the type of IP it is. Is it a copyright? Is it a trademark? Is it a patent? Is it a trade secret? You want to make sure that you have the full ownership. So we're talking about you licensing, not someone licensing to you, but you licensing your intellectual property. You want to make sure you have the full intellectual property rights. This is not on my notes to do, but I'm going to give it to you. If you hired someone to create something for you, even if you paid them, you still do not own the copyrights if it's not in the contract. That means whoever created your logo, whoever took photos for you, someone designed the workbook, whatever the materials are, you don't own it unless the contract said they transfer and assign all rights, title, and interest to you. I'm gonna give you another one, because remember, copyrights, the rights belong to the original creator, not the original buyer, the original creator who created the work. So if you have a 6-year-old little girl and you say, I need you to take this photo of me because I'm going to use it for my business, and they take the photo, your 6-year-old owns the copyright, not you, because who took the photo? This is what you want to go through before you try to license your intellectual property, is make sure you have the full ownership rights. And if you don't, you want to go back and get it. I'm going to give you this too. Just because a business, you hired a business, does not mean the business owns the intellectual property. Just because you hired a business, even your business, you do not automatically own the intellectual property you own for your business. It needs to be in the contract, because when you create for your business, if it's not in your LLC operating agreement or you don't have an IP assignment agreement, you still own it, not the business, because you're not an employee of the business. That means that in order for you to go back and get the copyrights, or even moving forward, anyone you hire, you want to put the business name in there, but you also want to put the individual creator's name, whoever worked on it, their name at the top, to make sure you have the full ownership rights transferred. All right. So you want to make sure that you have full rights to license the intellectual property. You want to do your due diligence. You want to make sure that if this is your property, no one has a claim to a claim in your copyright. So, for example, I did a podcast interview and there was no contract in place. The person who was hosting me did not know. At the end of the video, the person literally said to me, "I love the content that you shared. I want to be able to use it in my coaching program." Immediately, my antennas went up. What? You can't take my intellectual property. This person did not understand that because they did not have a contract in place that set the parameters of ownership, I have a copyright in that podcast episode. And if I have a copyright, I also have the right to demand certain things be taken out, certain things. So you want to make sure you do your due diligence to make sure that you own the fullness of your copyright, so that when you get ready to license it, nobody can stake a claim to the royalties in which you are getting the fee for your intellectual property. Okay. Next thing, if you are going to, here is what this I am not the typical attorney that says you got to register everything for brand protection. You want to identify those key pieces of your brand. And when I say brand, I'm not just talking about trademarks, but I'm talking about those key pieces of copyright material that you're going to be licensing. That if you're going to license it, you want to make sure you register it. Okay. If you're going to license it, register it. Copyright registration, if you know what you're doing, is like $65 unless you have to make the deposit. It's very reasonable. But if you are going to license a piece of intellectual property, and I'm not talking about ebooks, I'm talking about legitimate licensing for someone else to use, this is where you want to register, because you cannot sue for copyright infringement unless you have copyright registration. Y'all heard me? You cannot sue for, so if someone, you license your intellectual property out and they decide they want to take it, use it as their own, you cannot even get into court unless you have copyright registration. Now, if you register before infringement takes place, then it lists the burden of you having to prove damages, which means whatever the statute says you can recover, now you can recover that amount. But if you wait until infringement happens, guess what? Now you're going to have to prove it. And it's kind of tough to prove that somebody, to kind of prove the damages sometimes, because now you have to get access to the information. You have to do a little bit more due diligence. So if you're going to license it, copyright it. If you're going to license out a part of your brand, your trademarks, then you want to pursue trademark registration. And of course, my law firm can help you with both. All right. So that's to protect you. So anything that's in a fixed format that you're going to license out, you want to protect. All right. Okay. So number 2 in my notes, and I do apologize because we're at 1:30, but if you have some time, this is what you want to stick around for this part. So in your licensing agreement, you want to make sure that it is a licensing agreement that you're using. I'm going to tell you this now, okay? Because I deal with breach of contract cases. You want a contract in place if you're going to be licensing out your intellectual property. You want a contract in place, okay? And you want it to be very clear. So in your licensing agreement, you want to identify there's certain types of licenses. So now I'm getting into licenses. We talked about intellectual property. We talked about making sure that you have the right ownership. Let me give you this. Remember, I said that intellectual property is not protected as an idea. It's protected when it is in the proper context. For trademarks, you have to be using it in business as a source identifier. For copyrights, it just needs to be in a fixed format. But usually when you publish it, meaning you make it available to the public, that's where you have the most protection, okay? That's there. Now we're getting into the actual license. How do you license? So there's different types, okay? This is the way I teach this is I want you to think about children in marriages and custody situations. So parents that get divorced and what happens, they have to identify custody issues. This is the same thing. Okay. So you maintain full ownership of your intellectual property. This is what you want. But when it's time to identify the type of license, there are different levels to the type of license. So one is you have to decide whether or not this is going to be exclusive or non-exclusive. So in this case, think about dating versus marriage. If the license is exclusive, like marriage, that means nobody else will be, you can't license to anybody else. This is licensed just to this individual person or company. So oftentimes you may not want an exclusive license because it restricts your ability to license it out to other people. If it's non-exclusive, think about it like dating. You can date other people. We're not exclusive. The same is true for your intellectual property. The other is perpetual versus term-based. So perpetual, you may have seen this in contracts, perpetual or perpetuity is basically saying forever. I would never advise you to put forever. Just don't do it. Okay. You want to put a term. And so to make this easier, one of the things you can do is you could put a term, let's say for 1 or 3 years, and then you put the option to review it. No, Chris, no, forever, no. When it comes to your intellectual property, you don't want to be locked in. But if you're about to license intellectual property for somebody else, you want forever. You want exclusive rights. So always think about that in your contracts is that if you are receiving the right, you want exclusive, you don't want nobody else being able to use this. But when it's your stuff, you want the freedom to date around. Okay. We're going to put it in simple and you want the freedom to date around. Why? Because the freedom you have to date around, I'm just going to use this. It ain't true, but the myth that people have that women date to get free meals. You want the option to get your meals, which means you want the option to have more money coming into your business from you being able to license your intellectual property. If somebody wants an exclusive license, this is where, and I teach this, you have more negotiating power before you sign the contract. After you sign the contract, you don't have negotiating power as much as you had before unless it's time to renew it. This is why, if someone wants exclusive rights, the dollar amount goes up. Why? Because it limits your ability to date around and get more money coming into your business. So when we talk about the length of the license, perpetual versus term, if it is you licensing someone else's, you want perpetual. I want forever rights. You can't just, I don't want nobody else being able to use this. But, I don't want it to, I don't want to have to give up the right later on, right? You put time into maybe marketing, using this, you want to be able to use it forever. But if you are, say, for instance, you do a speaking engagement and they want to take the recording of your speaking engagement and they want to broadcast it. Well, now we're talking about a term. You can have the rights to do that for 1 year. After 1 year, we'll negotiate what the fee will be for another year. So in your contract, you want to have the term, but you also want to have the option to renew the license for a consecutive term. Okay. The other area is you need to consider is territory. So for some of you, your businesses will go global. You can actually limit the license for individual companies to territory and not just country or continent, but even select states. So some businesses are not all over. So perhaps if you are doing, you're doing training, consulting for organizations that have bases in different states, you could limit your licensing to just the West Coast. Here are the states where you can use this intellectual property, but you can't use it on the East Coast, or you can't use it in Europe. This is how you begin to be wise and actually create more revenue when licensing your intellectual property, because you start creating parameters. Remember I said leasing. Think about leasing. There are some places where they'll say you can't have visitors over for more than a select amount of days, or you can't do X, Y, and Z. You can't have a swimming pool. You can't have a fire pit. This is where you start putting parameters in place. Same thing. Um, Sub-licensing. So a part of licensing is also the ability to sub-license, meaning that they can license, if you license your intellectual property to someone else and you don't cover it, it means that they can license your intellectual property to a third party that you did not give permission to. So you want to put parameters on whether or not they can sub-license or they can't. If you're not sure of whether or not you're aware, like you're not sure whether or not you want to do that or not, you can literally just write in every sub-license has to be approved by you. That's it. That way you give yourself the option to say yes or no versus to limit it altogether. I'm looking at my notes here, but I want to give you something else. So we talked about territory. Other pieces of the licensing that you want to consider is whether or not you want to have it to be worldwide, meaning it can be everywhere. So that's the geography, or limited. Was it exclusive, non-exclusive? What do I put in my licenses? You also want to consider whether or not you want it to be limited or restricted. So for some of you, depending on the space that you're in, you may use your intellectual property in multiple spaces. So say, for instance, that you do leadership training, but you do leadership training in a corporate environment, but you also do leadership training for government, or you do it for government organizations, nonprofits. You may want to limit it to particular sectors versus allowing for them to use it however. So there are more limitations that you can add into your licensing agreement that allows for you to make sure, if I license it over here for corporate and maybe I limit them to the West Coast, I can also license the same intellectual property for the East Coast and do it for nonprofit or government organizations. Just more opportunities for you. Okay. And then you also want to deal with transferability. So we did with sub-license, but you also want to make sure they cannot assign the license, transfer their license to someone else. This is because you want to be able to control it. You want to be able to control who actually has a license with you. But I also, if you're thinking about this, you also need to think about the corporate, the business aspect. Some of you may start another business. That business is still connected to you, but you want to be able to sometimes assign those contracts to the other business. The same may be true for those who want to license from you. So you want to create parameters within your license that essentially says that any sub-license or any transfer or assignment has to be approved by you before it can be assigned or transferred. This allows for you not to shut it down completely, but to have complete discretion over whether to grant it or not to grant it. The next thing that you want to consider is the money. Okay, so there are different ways that you can do the fees for it. You can do fixed fees, meaning you pay an initial payment up front. You can do a fixed fee per term, or you can do royalties or percentage. You get to set that up depending on what you want. Can I tell you a secret? It doesn't have to be the same, even for the same intellectual property. You get to decide. So maybe for one company, maybe you're not sure about their ability to pay over time. So you want to do an upfront fee upfront and then royalties over time. Now, royalties depend on, you can set it up however you want it. It can be a set royalty or it can be based on something else. Say for example, you do a presentation and they want to broadcast it. Well, maybe you want to know the numbers, how many people are actually viewing this presentation. And then you do the viewers, you do a percentage based on the viewership. It's really up to you how you want to control the royalties, or you can just do a fixed fee or a minimum fee or a percentage based on revenue or sales if they're selling. The other thing is you want to have a payment schedule. So you want to be very clear on when payments are due. If you need an account of anything, you need to look at the books or sales. You want to write that into your contract to make sure that you get to see, okay, how much did they sell? How many views did they have? How many downloads? And that you receive that information by a clear date. If you're not sure what the date is, you can do it monthly. You can do it quarterly. It is really up to you how you want to maintain overview of what you're leasing in your intellectual property, but also think about your administrative responsibilities in your own business and how much work you're willing to do. Okay. You also want to think about auditing. So always have the right to audit the use of your intellectual property. Remember, I said you want to have some quality control. Auditing is a part of that. You want to audit to make sure that their books are accurate, they're keeping accurate records. This is how you make sure that you're not getting cheated out of the money that rightfully belongs to you if it's based on certain usage. But you also want to audit to make sure that they're using it for the permitted uses. So what is the scope of the permitted use for your intellectual property? Remember I said if you want to limit it to corporate, then they're using it just for corporate. Maybe you want to limit it for just leadership training. You want to make sure they're not using it for something outside of the permitted scope. So this is where your quality control comes in to make sure that they're using it for the parameters set forth in the contract. And here's the thing, you can even write into your contract a penalty fee. If you violate the permitted use, here's the penalty for it. So now they have to pay extra for using outside of the license because that's outside of the scope of the original license. This is one way that you can avoid a breach of contract if they just pay the penalty. And then you can negotiate the parameters for the additional license. If you are licensing your trademark, you definitely want to make sure that the trademark, when it comes to trademarks, you guys have probably seen the R. I don't know if I have anything in my parameters right now. No, you probably have seen the R. That is, when you see a logo that has the R there, that means it's a federally registered trademark. A trademark is not for everything you put it on. It's only for the classes of goods or services that it has been applied for. So that means that if you license your trademark, if they are using the R for a class that trademark has not been registered for, you can be at risk of losing your trademark rights if you don't file for trademark protection in that category because you're not using the trademark correctly. So you want to make sure that they're using the trademark correctly, but also the quality is up to your standards, because if not, then that can create some issues in the marketplace, but also some brand confusion issues. So you want to make sure that everything passes your inspection. One of the things that you want to write into your contracts is your ability to modify the contract. So modify the license, make changes as necessary to the IP. You have to write it in if you want to make sure that you have that right. And this is something else that I had recently had to do in my own contracts, is you want to make sure that you put non-disclosure requirements. Now, I'm going to say this: non-disclosure and confidentiality. Non-disclosure and confidentiality are two separate things. Non-disclosure means they just cannot disclose. Confidentiality gives them a responsibility, a duty to make sure they keep information protected. So when you are licensing your intellectual property, maybe one of the things you don't want to get out is how much they're paying you. Because if you're doing different prices or different fees for different corporations, maybe like a large size company is paying more than a small or medium sized company, you don't want that information to get out. And now you have a negotiation war when it's time to renew your licensing agreements. So you want to make sure that you put some terms. What do you want to keep secret? And is there some information that you don't want to get disclosed until a particular date, such as the fact that you're even in negotiation or in contract with this company? Okay. Other things that you want to consider, I know we're at time, and so I'm going to wrap this up, is you want to identify who is responsible for infringement, who is responsible for actually maintaining the protection. Because if somebody's infringing on the intellectual property, who's responsible for carrying the cost of that? Who bears the cost? Do they do it? Do you do it? What about registrability? What about the creation of derivative works? Who owns that? One of the things I like to write into my own contracts is that any derivative works, I still own, my business still owns the rights to that derivative work. So they can't claim ownership. You also want to write in, do they have to have insurance? Are they required to have insurance in order to license your intellectual property? And what level of insurance do they need to have? And then the other thing that you also want to include is termination and dispute resolution. So how does the agreement, if you're licensing, how does it get terminated? How do you resolve disputes? Because you're here, I'm going to give this to you. One of the things you have to understand about contract law and disputes is this. When you are licensing to people who are in other states, if every state has jurisdictional borders, meaning that if you're in Maryland, a Maryland court does not have jurisdiction over a California citizen or business. So how in the world do you get them to be able to sue in a Maryland court or a DC court without having to travel to California? You put it in your contract. You have to have it in your contract. If not, you are not going to be able to get into court as easily. Or you're going to have a war about transferring the case to another court, which adds to your litigation costs. This is one way that you protect your brand, especially with licensing, because when we talk about licensing, you're really dealing in contract law as well as intellectual property law. So you want to make sure that your contract is very clear on where disputes take place, but also setting the venue, a venue selection, and making sure that both parties consent to the jurisdiction of the courts in that jurisdiction. Because if not, you're going to have a battle on your hands. Okay. Of course, you want to have grounds for termination, breach of contract. You want to have your notice requirements. How much time do they have to let you know that they're going to terminate the contract? One thing that I want to add here is your right to stop misuse of intellectual property. You want to make sure that you have the right to stop any misuse of property, but also you want to make sure that you have rights written in on what has to happen once the contract ends. Do they have to delete all files of intellectual property they have? They have to turn it over to you. You want to be very clear about what happens afterwards and any penalties of using afterwards as well. The type of resolution, is it going to be mediation? Is it going to be arbitration, or can you just go straight to court? One of the things I will give you is you want to have a class action waiver. The reason why is because if you're going to do intellectual property licensing, chances are you're not just going to do it with one company. You want to make sure nobody can join together and join forces to sue you in a class action. This is how, remember I told you I trained as a litigator, right? Okay. This is how you keep people from bringing their funds together, because when people can do a class action, that means they can join their resources to sue you. But you don't have those resources oftentimes. So when you keep people separate, most people don't have the money to hire an attorney and to sue you. This is how you keep litigation out. Okay. And then I'm going to give you something, but I'm not going to put it in the recording. I'm almost at the end. Yep. And you want to make sure that you have record keeping. So I think that is all that I have for that. For licensing, these are licensing basics. This is just the basics I'm giving you. And so when it comes to licensing, you want to make sure that you have it in the contract, and your contract has the main provisions that you have. And so I went over all of that. This, again, is the first legal pop-up of Legacy Legal and Consulting Firm. If you need help with licensing your intellectual property, with registering your intellectual property, you can schedule a free discovery call to get started at legacylegalconsult.com. And for those of you who are still on, just wait a second, because what I'm going to do is I'm going to stop the recording, and then we're going to get into the Q&A session, which is just for those who have registered. So if you register, you will get access to it, but I'm going to give you one thing that I'm not going to put in the recording.